Okay, so we'll go through most of this. Honestly, the only complicated part of the listing agreement really comes into the actual representation, the commission part, and then the clear cooperation part. Those are like the big three that we really focus on. So the first part of it, just like any of the documents, you'll fill in the information here. It is best to make sure that you double check who the actual owner is. You want to make sure that you have everyone who's on the current deed. We'll be signing this as well. You can do a deed search for each one of the counties. That would be a good way to set it up. It could also give you a good insight if there's been changes in the deed. A couple times, like if you try to search our name in the deeds of Charleston County right now, it looks like there's a whole lot more than there is, just because we've changed things. We moved it into a trust and did a couple things. So if you see a lot of changes on there, it's a good thing to know ahead of time, just in case you need the sellers to clarify who's currently on the deed for their home. Things to be on the lookout for would be
so when you do a listing agreement with the client, you have to check before or after that they are actually on the deed.
It would be a better thing to do. You can start with the tax records, but that doesn't always, the tax records are really only as accurate as the person who inputted them, right? So if they miss something from the deed, this way, if you go straight to it, you can take it from the deed.
Yeah, because you can check that in MLS, right?
The tax records you can, yes.
Tax records.
So yeah. What couple things to look out for really show up when it comes to situations, marriage, divorce, or death. If you've got a couple that's married, it may have been, one of them bought the house prior to them getting married, so it may actually only be one person on there. They may have actually added the person to it. Or if you have a divorce situation, you want to make sure that the house was properly deeded after the divorce, or if it wasn't, that they're able to sell it. And if there's any paperwork to need to go through from the divorce decree. And of course, death, if you have any, an estate, you want to make sure you have the right person that's handling it, the right paperwork to be handling it. If at any time you get into those situations that may be tricky, it's always best to go ahead and engage whatever attorney they want to represent them at closing. So if you do get that situation early on, it would be best to say, hey, Mr. and Mrs. Seller, we highly recommend that you go ahead and engage an attorney to represent you on the closing side. You can recommend one of the law firms. Most of them do separate representation now. That way, if they do need to run a title search or do anything early on, you can pick anything early before you get a contract. So the period of time beginning on this is the actual effective date of the listing agreement. So as it relates to the NAR and the clear cooperation policy, it does mean from this date right here where it says beginning on. So I'll use today as an example. Today's October 18th, but let's say you wanted a listing that wasn't going to go on the market until November 1st, and you put November 1st in here. The rules for it to go into the MLS don't trigger until November 1st. However, if you do have a date that's later than today's date on here, you don't have a valid listing agreement until that date starts. So in that same example, Jay and I sit down. Jay says, yeah, I want to list my property with you. Starting on November 1st, we sign it, we move forward. Jay goes to a cocktail party this weekend, meets another agent who oohs and ahs him, and he says, you know what, this guy seems like he'd be a little bit better, signs that listing agreement. That agent didn't do anything wrong because you technically don't have a valid listing agreement until the actual start date on here. Okay. And when we get to that part of it, we'll talk about ways. Yeah, we'll talk about ways to get around that, or to deal with that, I should say. Let's not use the word get around.
Okay.
So,
oh, well, dealing with it is getting around.
Said get around, and it's recorded. I'm just putting that out there.
Yeah, I appreciate that. That's good. We might lose this one. So the legal description in here, you want to have as much of this filled in as you possibly can. If you can't get the lot block section from the MLS, from the tax records or the deed, put a dash in there or something. Your big ones are going to be the address, the tax number, and the county. There is a part in here that says basically that any improvements, fixtures, anything additional to the property includes what's here. So you do want to make sure that you use this more as a reminder to talk to the seller about what their expectations are. So Mr. and Mrs. Seller, when you walk me through the house, what do you anticipate taking with you? So if they come through and they want to take the fridge and they want to take all the window treatments and they want to take the dining room chandelier, know that ahead of time so they can go ahead and either address it, or for instance, if you have lighting that they're going to change out, you do that before you go into the MLS, and you have all those things done ahead of time so it doesn't cloud the negotiations. Section 1 is basically in this is where they talk about the disclosure and then acceptance of potentially considering dual and designated agencies. So this is one of the times that they say, they do initial that you have explained to them and giving them the South Carolina Disclosure of Real Estate Brokerage Relationship form. So make sure you have gone through that before having gone through this, because you don't want to be reminded of a form that you should have already told them about halfway through the next form. It's just small things like that over time could etch away at their confidence in you. And then keep in mind in this, particularly when you're with a brokerage, we've got, the potential for designated agency is a little bit higher because we do have the same broker of all the local offices. So with 375-ish agents, there could be a chance that designated agency would happen. So I would just make sure you explain to them, it says, may be considered at the time that you provide the information. The reason I say that is, let's go back to the example. Jay and I sit down and Jay's like, hey, I don't know that I would really love designated agency or dual agency if, the buyer was related to you or anything like that. You could say, totally understand that if that were to, so this isn't saying you absolutely will take it. However, if I do have an agent from the Somerville office come and show your property here in Mount Pleasant, that's designated agency. I don't have any relationship with that agent. There's really no conflict of interest there other than the broker being the dual agent. That would be something you would want to consider. If it turns out it's a situation where, I'm representing Jay, and then I come to him and say, hey, my sister's moving in from Atlanta. She wants to buy a house and she wants to buy your house. Jay may be a little more reluctant at that point to feel like there'd be an equal balance of representation in a transaction where it's, a blood relative versus my client. So again, it doesn't commit them to agreeing to it. It just says that they will or will not consider it. Section 2, basically, this is where we talk about the terms of the contract. This is where you put the price in the contract. TBD is not a valid price. And I know people laugh. I used to do it. If you are still waiting on a final price, let's go back to the first example. Jay's listing his house with me, but he's not putting it on the market till November 1st. We agree at $400,000, but the neighbor's house just went on the market at $410,000. He wants to see where it closes. If it does close at say $425,000 or somewhere where Jay would want to change the price, you can always amend that price later. So in that situation, if Jay were to say, well, I'd rather wait until, we go live before I agree on a price, then you at that point would say, well, then let's agree on a price now and have the understanding that if we change that price, we can. Again, if that's something you're willing to do as a business person, if they're trying to go higher before they should, you just have to kind of use that on a case-by-case basis. You do spell out the terms of the contract as far as the wording of the price as well as the numbers. And then this is where you will add in the total broker fee here. It's either going to be a dollar amount, which we hardly ever see. So you basically just put NA in there and then a percentage. This would be where you put the total amount. So in a traditional situation, which we see most of the time, is you'd have a 6% commission. You'd put 6% here. Later in the contract is where you would determine how much you're offering out to the co-ops. I'm not going to go through all of these. I do want to point out, though, that the protection period here, which says that the property is sold within blank days of the expiration or termination of this agreement, to a buyer to whom the property was shown by the owner broker or another broker or any person during the time of this agreement, the broker's fee shall be payable to the owner. This protection period shall be terminated if enters into a new listing agreement with another broker during the protection period. So let's just say that it's sold during this expiration term. So let's say Jay and I, we move forward. He lists his house with me, and then on November 1, he decides he wants to take his house off the market. If let's say we just put 30 days in there and it's November 1, if anybody who had shown the house before, has actually seen it, not just anybody. This is a little bit of a change. It used to be open-ended. This is, if it has been shown to someone during that period, it doesn't mean that I had to have shown it. Could have been shown by a different agent or whatever it was. But
30 days, you said?
Most people will put 30 days.
You put 30 days?
You can put whichever one you like. Yeah. If they come in and purchase it, then Jay would still be liable for the commission to be paid to me, which would obviously then be paid, partly to the buyer's agent if there was one. However, if Jay decides to relist his house with another broker during that period, then that would cancel out this protection period. So if Jay decided, hey, I'm going to actually go list with, Matt O'Neill and then list then it would terminate this protection. There is a technicality in this that we just need to be mindful of with multiple offices, and that is if the owner enters into a listing agreement with another broker. So if Jay, in this same situation, let's say Jay hired me, he terminates it. I shouldn't have said me. Let's say Lydia. He hires you, and then you guys decide to terminate that relationship, and then he goes and lists his house with Winnie in the West Ashley office. Technically, that is not another broker. So it would technically not terminate the listing period because it's not being listed with another broker. However, anytime that we've had that situation, we've just had internal documents that work that out and protect those specific buyers. We can work it out when we get there.
Isn't that similar like with the new construction too, when you go and introduce your client to a builder and
no, well, that would be per builder on that one. That would be a separate situation on there if they were going.
But there's a protection period there too.
That's specific to each builder.
Oh, I see.
Some don't have any. Some are very strict.
I think they have to sign some.
Yeah.
Mm-hmm.
All right. Section 3 is where we talk about the compensation to other brokerages. The only one we do not pay out to is sub-agency, because technically there is no sub-agency in South Carolina. You default to transaction brokerage, which is non-agency. I am a firm proponent of you offer the same to pay any of these. So a buyer agent or a transaction broker, if you're offering 3% to one, offer 3% to the other. There's no reduction in liability or increase in liability to you if the buyer has chosen not to be represented, but wants an agent to walk them through as a transaction broker. So I have quite a handful of people, mainly in the Mount Pleasant office right now, that because that wasn't accepted in the beginning, still kind of transferring that mentality over. West Ashley, we're still kind of, we're a little bit ahead of it only because we started accepting it a little bit earlier. It's just more of a reminder. People's habit goes through. They put 3% for buyer agent, 0% for transaction brokerage. You just don't want to deter anybody from coming and showing the listing. That should be about the same. Earnest money, earnest money is always, we can go through word for word on these paragraphs. At the bottom line is you need to explain to your sellers that when a buyer puts in an offer on a property, they're going to put up what we call earnest money, which is a promise to perform on the contract. It is not a guarantee for you to get money if the buyer defaults. It's not a punitive amount. It's a contract, it's an amount of money that the buyer puts up that says, hey, I'm going to move forward with this contract to the best of my ability. Now, in the event the buyer does default and it's quite obvious, what we have to explain to the client is, even if it's very obviously defaulted, earnest money is regulated by the state, and no escrow agent, whether it's another brokerage, an attorney, or whomever, can just blindly release earnest money. There has to be an agreement signed by all parties or a court order to release the money. So we just want to explain that to them. This is one of the many times we'll explain that to them. We just want to make sure that we do. So this is where you go through your broker's duties. This is a great place for your listing consultation to talk about what you're basically doing. You're going to employ your best efforts for you as the broker, as well as the agents in our office, to secure a contract of sale for this property. That you're going to keep them informed of the progress, finding the buyer. We're going to make sure that there's no representation or guarantee as to the sale of the property that can move. We are limited on the liability side of things. So the seller just needs to know from this paragraph here, it states that the brokers can't be held liable, particularly if they fill out a property disclosure statement, to any omissions or concealment that the sellers have on the property. The owner's duty on this one, this is a good one. This is a good expectations conversation to have. Furnish the broker with complete and reliable information to inform them of any inquiries that come on the property. So if they're there, cutting their lawn on the weekend and somebody stops by, this is basically saying, hey, this is where I will make sure I put them directly in touch with you as my agent. This is one that's been kind of interesting. It's come up quite a bit. Permit inspection and showing of the property by brokers, agents, buyer agents, by such agents, prospective buyers, as deemed reasonably necessary by broker, and to cooperate in the scheduling and carrying out of such showings and inspections as is necessary. Again, I don't know that I'm going to read that paragraph to them yet. I am going to kind of make more of a mark in my listing consultation to say, hey, just so you know that the buyer is going to come look at the property. And then after they go under contract, they are going to want to inspect the property. Sometimes that can be more than one inspection. Sometimes that could be different types of inspections. That'll always depend. But I just want to make sure that you as the seller have the right expectation that it doesn't really do us any good to deny any inspections, even if they're out of the inspection period or anything like that. Like let's have a cooperative environment moving forward with a buyer. The contract also protects that. You just want to make sure that the seller knows that, once they get a contract, it's not over as far as them letting people into their house. It's not going to be an open door or a revolving door. Then they should just expect that there can be some opportunity for some multiple inspections. There is a part in here for the broker to incur on behalf of the owner reasonable expenses. You only really see this happen if if you manage any work that's being done on the property, you have the utilities put in your name or anything like that, you would address that here. If you get those situations, come to me, because make sure we can just cover yourself on that. And then some other, technicalities, stipulations in here, which basically would be, they're going to pay the compensation out of the closing, that they're going to let us publish all the sales data through the MLS. We will have photography taken of it. The owner understands that all marketing materials, including but not limited to photographs, brochures, websites for sale of subject property, shall remain the property of the broker. The reason that's kind of important is we have had this come up the last couple months a few different times where, either be after closing or if they terminated the listing early, sellers being very particular about pictures still being out on the internet. When you go over the photography part of your consultation, you do want to kind of tell them in diplomatic but clear ways that, once the toothpaste is out of the tube, it's really hard to get it back in. So, just want to let you know, Mr. Seller, that if we are going to put pictures on the internet once it closes. Obviously, we can take them down. We don't typically take them down. We have to leave at least one up. So I just want you to be cognizant of that. So if you do want to change up some of, where this shows up, some would be personal items in the photos, children's rooms with their names in giant letters on the wall, those sorts of things. You just want to have that conversation with them. You do want to have them to convey marketable title. That's part of their duty. They're going to, the owner's attorneys are going to furnish us as the seller, or excuse me, the agent, to see their settlement statement. They are agreeing not to deal directly with buyers, written instructions for confidentiality, etc. All right, so I'm going to spend a little bit of time on this one because there's definitely been a misunderstanding on this that's been 100% driven by how do I word this? Kind of an overstepping of what the MLS should be providing, because they've provided a list of exclusions from the property disclosure. In a nutshell, there is not a situation that we're going to be dealing with where we should comfortably justify our client not filling out a property disclosure. Okay, there are a list of exemptions that do come from South Carolina law. Those exemptions look like this. Basically, what happened a couple of years ago is someone from the MLS took this list of 15 things from the license law. They copied and pasted into this document and made it a document that everyone signs. This is not a good idea at all, right? First of all, none of these are really ever pertaining to our specific situation. And here's what I mean by that. And I don't want to get bogged down in the details, but I do want to make sure people understand. So the big one that we get is a lot of people say, it's they've never lived in the house. Well, there's nothing on here that says that they haven't lived in the house.
You've been breaking up on that one.
One of the reasons that people get is that they haven't lived in the house. That's not a reason to not fill out the property disclosure. If they're flipping the house, that's not a reason to not fill out the property disclosure. What we have happen a lot is people will say, well, they got it at foreclosure, so that was by in a foreclosure sale, when it's basically taken by court order, then that's an exemption. That's correct. It's an exemption that when Jay forecloses on the property and it gives it back to the bank, he didn't need to fill out a property disclosure back to the bank. But if the bank then sells it to someone, they do. Or if I bought it as a foreclosure and sell it to someone, I do have to fill out a property disclosure, right? If I'm a representative of the estate and I'm selling it to Jay, I acquired this. Let's say it's an heir's property. Let's say my mom passes away. I acquire the property in the estate, in a will. Well, that transfer from my mom to me, I don't need a property disclosure. That does not mean I don't need to fill one out to then go sell the property to Jay. So it's not you acquired it that exempts you. It's the actual transfer between the two people. That's been a big misunderstanding. And then the other problem that we have in here is this default number 13 right here, where it says between parties when both parties agree in writing not to complete a disclosure statement. So the reason that's bad is if you don't have quite frankly, from a buyer's agent standpoint, it puts you at bigger risk, because the law states that any transaction, any transfer of real property in the state of South Carolina, the seller is required to fill one out unless they have one of these exemptions. Well, this added little thing of everyone agree is basically saying two people are now agreeing to not follow the law. So where it happens, and this is kind of a liability on our standpoint, this adds an extra layer of protection for both your seller as well as you as the listing agent, as well as you as the buyer's agent. It's not saying it's the end all be all to the buyer, but it is saying, hey, as an agent and the fiduciary of the transaction, you should have known that it is the law that they needed to fill that out. So you should push back for it. But technically, and I'm having a discussion with the association right now, technically as a buyer's agent, you should be pushing back if you're showing a property that doesn't have a property disclosure filled out, because your buyer has not agreed for them to not fill it out. The seller has said, hey, I want you to agree for that, but the buyer can. But don't you have to have a disclosure when you make a listing? That's what I'm saying. Yes.
In MLS?
Yes.
Okay.
So just something to keep in mind on that. Yeah.
The buyer can come later,
Right. All right. So I'm going to jump down now, because the next part is on disclosure, that you're authorizing the broker to disclose information about the property, which is basically saying after you fill this out up here, you're going to let me start sharing the screen again.
Joseph, while you're talking about 13, because that's the whole reason I'm here today, is you've pushed back, but they just refuse to engage it. Like, what's a appropriate course of action, especially if your buyer wants to buy the house?
Yeah, I mean, at the end of the day, then we just explain to our buyer the risk. And quite frankly, in that situation, that's why it's a bit awkward, is the risk is really not to them as much as it is to you as their buyer's agent. Right. And at the end of the day, the buyer's going to be like, well, sorry, but I want to buy the house. So this isn't necessarily the hill that I would die on. I would try, and if you feel like it's one of those where, we can make a call to the other broker. We're starting to see fewer and fewer of them happen, because I feel like the brokers are starting to get out to their agents a little bit more to say, hey, fill it out. So if at the end of the day, they do have that agreement that's in there, especially because, again, it's very hard for me to sit here and say this when I literally pulled that form straight from our local association as a resource, which I have requested to be addressed, but we'll see. So in that case, just use your best.
This was the first time I've encountered it where they just wouldn't do it. And so I had him sign it, but we talked about it. I was like, it's a flip. And so in fairness, when they filled it out, they didn't know a lot of the answers to the questions. And now they do. So I've actually asked the listing agent, hey, could they fill it out now since they actually know the answers?
Right. Yeah, and that's where you'll see a lot, which is really one of the more glaring thing. That's one of the more glaring situations of why it doesn't make sense, because especially in a flip, if this person has literally gone in and gutted the house and come back, they should know more than you or I would as general resale sellers, right? So again, it's I'll be curious to see where that goes. But to answer your question, at the end of the day, here's the other problem with this, Jay, is at the end of the day, there are some attorneys who would argue that once your buyer signs a purchase and sale agreement, that the seller's disclosure is null and void, because there's a paragraph in the purchase and sale that specifically says you're not relying on any other documentation. You're doing everything through this document now, including getting your own inspections and do everything. So it's not a perfect system.
Nothing ever.
All right. No, of course not. All right. So let's jump to section 13. So this is the one that's just everybody's super fun right now. So 13 is basically addressing the multiple listing service public marketing. You have two options that would go into this. Typically what would happen, normal market, normal situation, option one was what you would do. Property shall be entered into the MLS service of which the broker is a member within the time frame stipulated by their bylaws, rules, and regulations. This shall constitute an offer of a cooperating brokerage to all members of the listing service. Owner agrees that the broker may compensate an agent representing the buyer in the fee described. Owner agrees or does not agree that the listing will be placed in electronic mediums, included but not limited to the MLS, IDX program, similar online computer services, but it will also have their property address and everything else in there. Owner further agrees to permit other real estate firms who belong to any listing services of which the broker or member the listing on the internet in accordance with the listing service rules and regulations. Bold here, broker and owner agree to abide by all rules of the multiple listing service on which the property is listed. All right, so that's option one. I'm going to go to option two, and then we're going to walk through 10 different scenarios that can happen. Option two basically says that the seller does not consent for their property to be entered into the multiple listing service and instead wishes to have their property listed as a brokerage exclusive. This will prohibit the seller and broker from conducting any public marketing, which includes but is not limited to site signage, social media, etc. of the property, and will restrict the marketing of the property to only the members of the broker's firm. Broker and owner agree to complete any paperwork required by the multiple listing service of which the broker is a member to verify the property will not be public marketed. Okay, so here's what all this is based on. This is all based on the NAR's clear cooperation policy. So that's where we start. So the NAR clear cooperation policy says, well, actually, we start with license law. So license law in South Carolina states that you cannot advertise someone else's property without written permission from the owner of the property. Okay, so in order to be able to market the property at all to anyone, you have to start with a listing agreement. That's the owner's written permission. Okay, so that's where you start. So you get the owner's written permission here. What the NAR policy says is that as soon as you start advertising that property to the public, then you have to follow the NAR clear cooperation policy, which is within 1 business day of marketing it to the public, you will enter it into your local multiple listing service. Okay, so that's kind of where we are so far. We've got license law states we have to have a listing agreement to advertise. NAR states as soon as you advertise to the public, you have 1 business day to get it into the multiple listing service. Okay, so what we're doing right now is option one. Option one basically states that yes, the seller wants the property put into the MLS and agrees that they'll follow any of the rules or anything to abide by as far as the MLS and NAR is concerned. So if you were to sign this today, and I'm going to use the example of the even numbers that we did with Jay earlier. Let's say we signed the multiple listing, the listing agreement today, but Jay doesn't want to go into the MLS until November 1. Well, there's 2 ways that you can do that. Number one, you put November 1 at the very top of the agreement to start here. So from the period of time beginning on November 1, that's how you would get, that's basically how you abide by the rules and do everything there. Now, between now and November 1, Jay cannot tell anyone or cannot do any public marketing on the MLS or about this property. If he does, the moment he does, it has to go into the MLS within 1 business day. Even if then that, which means he'd have to change his listing agreement. Now, quick technicality, not to get all nerdy on you. Technically, this is a good example of why you always start with the law. Because what was the one thing that we had to have in order to advertise someone's property?
Written agreement.
Written agreement. So if you have a written agreement that doesn't start until November 1, do you have permission to market the property?
Not until November 1.
Not until November 1. So technically that takes care of this. You shouldn't really worry anything about it. Now, here's what we know what happens, right? Jay's going to start cleaning his yard. He's going to start painting the house. Someone's going to come by. He's going to post on Facebook, somewhere, whatever happens here. So then what happens when you start publicly marketing? And this is where it gets super fun. So it does say in here we have to abide by our local MLS's rules. So our local MLS has changed it up a little bit. What the local MLS says is that within 7 days of your effective listing date, which is the date that's on that first paragraph, right? The November 1 in this example, it says within 7 days of then, I have to have it in the MLS. Now I can have it in the MLS as coming soon, right? So I could put it in the next day, have coming soon, but I can't, and then I can market it to anybody publicly at any time. Or let's say we sign it, and let's say we signed it for today, October 18th. We can wait 7 days before it goes into the MLS by selecting option 1 here. However, if we market it publicly at all, it then has to go into the MLS within 1 business day. So you've got those 7 days before it goes in that you can't market it publicly. And if you do, it triggers the NAR rule. Then once you go into the MLS, you now have a 7-day window where you can market it as coming soon. And then coming soon basically means it's in there for informational purposes only to the agent body. It does not go to Zillow, does not go to anything else. It simply goes to the agent body. But it is technically, according to NAR's rules, it is in the MLS at that point. You can tell anybody and everybody about it. With me so far? Okay, so let's say we have a situation where Jay wants to have his cake and eat it too. He wants the couple weeks to get it ready, but he wants as many people to know about it as possible, but he doesn't want to go in the MLS until November 1, where he then gets the 7-day grace period or whatever it may be. That's when you would go to option 2. Option 2 on here is the brokerage exclusive. The brokerage exclusive basically says that they don't consent for the property to be placed in MLS. However, the broker, meaning Jay or me as the agent, as representative of the broker, can go tell any of the other agents in the company as well as their clients, not customers. They can only tell their represented buyer clients about this property, right? And so again, anybody outside the brokerage, it then becomes public marketing. So if you do know you're going to put it out there and you have buyers that come and say, hey, or you got it, let's say Jay takes a listing and he puts it on the Charleston Facebook page. And then when he comes by and says, hey, I've got a buyer that wants to see it. Well, as soon as we tell that buyer, we've gone public. So if we have option 2 checked off here, we're fine because they're represented by Winnie. But if we had option 1 checked off, we're not.
So is it fair then to assume, and correct me if I'm misassuming, but is it fair then to assume that perhaps what you're suggesting here is that we would do option 2 if they wanted to do some sort of, getting things ready and we wanted to make sure we go ahead and lock it down, and then we do option 1 at a later date?
Yes. So yes, that would be the cleanest way to do it. And here's why. So when you do this, you'll remember that down here, it says that they agree to complete any paperwork required by the multiple listing service. Okay. Right. So if you do option 2, you then have to fill out this form, which is on the same form as this terrible thing. It's called the office exclusive form. And this basically fills out that you are, and this is an over disclosure on their part, and I get it. And quite frankly, this is why everyone doesn't like this office exclusive thing, is for these things right here. It's saying, hey, you're agreeing to not go into the MLS and go live to all the other brokerages, which is over 7,000 real estate agents, automatic syndication, IDX, all these things they're not wanting to do. That's fine. Says the seller and broker, along with the listing agent, have entered a listing agreement with an effective date of blank, the start date, which will match your effective date here.
Right.
Okay. And an ending date of there. Okay. Now, it does give you a deadline where this kind of automatically moves to option 1, Jay, because it goes, there's the acknowledgement. The first one says the seller acknowledges broker and listing agent participate in the Charleston Regional MLS and are subject to their rules. The seller has instructed broker and listing to not disseminate seller's property listings via the MLS to other brokers and agents. And the seller's property listing should be office exclusive, either the entirety of the listing agreement or until blank, at which time the seller authorizes the broker and listing agent to submit it to the MLS.
Okay, so that basically allows you to not have to fill out a new listing agreement. Correct.
It's the reason I don't love it is you would then at this point want to add here,
right?
See attached paperwork, because you want to make sure it connects the two
included.
documents.
Right.
Yeah.
Okay.
And then basically it's the acknowledgement of everything else. So that's just a super long way of saying that to do what you were doing is you'd select option 2 and then you'd fill out the date of this one. Then you have to submit this form to MLS. You send it to supported MLS.
So you have to send it in.
You have to send that form in, yeah.
Hey, hang on one second. Okay.
Because what happens is if they get a call, so let's say for whatever reason, it's basically an accountability side of things. So if they get a call and they say, hey, I don't know when they'd find out, because if they found out from anybody outside the brokerage, then we'd have to have, that would be public marketing, but they do have to have this on file.
Okay.
So, and then the rest is basically just kind of acknowledgements. All right. So going back to the rest of the listing agreement, Lydia, I'm going to kind of go through these fairly quickly. I know you've got a little bit tight on time, which is good. But so yeah, section 14 is the lockbox, whether or not the owner does or does not agree for the lockbox. If you do have a tenant occupied property, you will want them to have the lockbox addendum filled out. Otherwise, this would cover that. The rest is really disclosures, right? They're not, commissions are negotiable. We will still market the property as active contingent, so it won't be fully active. I do have to present other offers to you as the agent. The seller does agree to maintain the property in its same condition from the effective date until closing. They agree to sell, they agree to sell. They'll participate in any lead-based paint disclosures. We agree to mediate versus sue each other should you and I, as the listing agent and the seller, have any disagreements. Fair housing, owner and broker agree the property is offered without regard of any of the protected classes. This actually does need to be updated. It doesn't have them all in there. We can use facts. It is an enforceable contract. Any sex offender criminal information that is up to the clients to find. Photography will be taken, and all photography is irrevocably conveying to the listing agent that they are going to surveil the property during showings, that they will follow the law. And then the other terms and conditions is where you would put the information regarding if you had an easy out, change in commission, anything like that. All right, any questions, Lydia? I think you're muted. Yeah, I can't hear you, Lydia. If you can hear me, you're on mute. There we go.
Yeah, I'll have to come to it again. You can't absorb everything in one
No,
time.
you can't. Again, that's why we repeat the bigger topics like this.
A lot.
Good.
Good. Well, I'll find it. Because I took some notes as you were talking on certain points, but certain I missed. So
okay,
that's okay.
Well, it'll be posted so you can watch it again. And then there's one that there's one from a couple weeks ago that follows just in the section 13 regarding this. I'll probably do another one.
Oh, okay.
Yeah, I'll probably do another one on that. Just that one as the broker minute. So
great. Thank you so much.
You're welcome.
Okay,
Thanks
I'll
for being
see
here,
you
Jay.
next time.